Good morning, everybody. Welcome back to the Law and Crime Network. This is our first show in 2018, and as you can see, there have been some amazing changes. Really, we have a brand new studio, a beautiful lineup set up for this entire day and as well as this whole new year. We really do appreciate you joining us. Happy New Year. This is going to be a very, very exciting time for you to be joining us. We have brand new changes here, and we, again, thank you for joining us. So again, this whole year will be filled with brand new trials. We'll be covering top legal cases, expert legal analysis, some fun segments. It's just going to be continuation, bigger and better in this brand new, beautiful studio. And again, let's start for the day. We have a big day today. First thing, what we're going to play throughout the rest of the day is the Quinton Tellus replays from that case that we covered in 2017. Now, why are we covering that? Well, we anticipate in this year that Quinton Tellus will be retried for the death of 19-year-old Jessica Chambers. We believe that he will be retried this year. It will be a huge case to come out this year because it was a big case in 2017. And as you know, it was this really, really disturbing case out of Mississippi where a young 19-year-old girl was burned alive, and Quinton Tellus was on trial for her murder. However, a jury couldn't decide one way or another whether this man was in fact guilty. And for anybody who followed this case, there were a lot of question marks about whether or not he was guilty. So what we are going to do today is replay different parts of that case so you can stay up to date on it and understand what we anticipate moving forward in 2018. But that's not it. We have a lot of special segments today that are really, really important. This morning, we are going to be covering 4 different cases that we'll talk about, everything from a girls-only show and a man suing for gender discrimination, not lying about that one, to 4 teens being arrested and charged with murder for allegedly throwing a sandbag over an overpass and killing a motorist. We also have a new DUI attorney service out of Oklahoma City that basically says if you pay $20 for a flat fee, you will be provided an attorney in DUI arrests. We'll talk about that one as well. And then we're going to talk about this morning a first date gone terribly wrong. You're not going to want to miss that. We're covering those 4 trials. Now, later on in the day, we'll also be covering the top 10 celebrity lawsuits of 2017. We will be covering another issue about Call of Duty, the video game. Later on today at around 1:30 p.m., we're going to live stream the Brevard Bond Court out of Florida. Again, this is we're going to show you a live feed into that bond court where different people who have been arrested are brought before the judge, and a determination about bond and the future of their case will be presented. And for people who've been following this on lawandcrime.com, there's some really interesting stuff in those court hearings. Really, really fun things to watch. So we're going to be covering that live later on in the day. And then we're going to close out the day, our first day in 2018 with our Law and Crime Network, with the top new state laws that are coming into effect in 2018. So we have a busy day, but don't worry, we're all here to work it out with you. And I want to start off with those special segments, those special cases that we talked about. And to start our first day here on the Law and Crime Network in 2018, I'm joined by 2 very special guests. First, in studio, criminal defense attorney and former prosecutor Bob Bianchi. Bob, great to see you.
Great to see you, Jesse. Happy New Year.
Happy New Year. Happy New Year. And then joining us via Skype is criminal defense attorney Jayne Weintraub. Jayne, great to see you and Happy New Year.
Happy New Year to you.
I love this. I have 2 criminal defense attorneys. I feel a little nervous. I have one in studio, one on Skype. I feel a little nervous. Should I be nervous?
You should have been more nervous when I was a prosecutor. A criminal defense attorney, I got you covered.
That's true. That's true. Well, the great thing about having you both on is that as we cover these 4 new stories, I'm going to get a different perspective from each of you. Are you guys ready to do this?
Let's do it.
All right. I want to start off with this interesting case about comedian Iliza Shlesinger. Now, she is being sued alongside a Los Angeles theater for gender discrimination over her girls-only show, Girls Night In with Iliza, No Boys Allowed. Apparently a person who purchased a ticket for this show, a man named George St. George, filed a lawsuit against her. And he said that he purchased a $30 ticket for her November 13th performance, while his guest purchased one for $25, 2 men. It is alleged in their complaint that the theater would admit them to the show, despite the fact that they were males, but that both of them had to sit in the back of the theater because of their sex. However, they were apparently both turned away when they later tried to enter the theater closer to showtime. They are alleging gender discrimination. I want to start off with Jayne. Jayne, you've heard about this case. A lot of people are criticizing the two men here. Do they really have a case here?
You know, I don't think that they do. I think that she has the right to perform for whomever she wants. Remember, we have a First Amendment, which gives us freedom of assembly, freedom to associate with whom we want. And with that, I think, goes the freedom to perform. You know, she's not denying them a government benefit. This is not to be confused with hiring or firing or discrimination. This is her choice with whom she wants to engage and perform for. So therefore, I don't think that it's a worthy lawsuit. And besides, you know, the men could go right next door. They could do the same thing. So we're not depriving men of something similar. We're just saying this is our right to associate as women in this performance.
Now, Bob, again, isn't this really against the law? Isn't there a law in California that goes directly against this? Aren't they being discriminated against by their sex?
There is a very clear law, and it's surprising that this would be occurring. Let's do the good for the goose, good for the gander analysis, legal analysis. Could you imagine if a group of white people said, we are going to have a show and only white people in a public theater or a public accommodation scenario can come to this show? Black people are excluded, Jews are excluded, Hispanics are excluded. People would not view this case the same way. It's one thing to have a female gendered. It's one thing to have a female gendered show that has female themes and things of that nature, but to deny access under the California law, which says you cannot deny, even as a private business, based on sex, national origin, creed, religion, things of that nature. This is a no-brainer of a win for the plaintiff in this case, for the men in this case.
Jayne, it's they're being discriminated against by their sex. No, how is this different?
Discriminated against. They are not being included in a private gathering. You know, private clubs are still allowed to exist under certain restrictions.
But what's the difference between that? What's the difference
between
between
that?
This
isn't a private club. It was open to the public.
Right. Aren't they selling tickets to the public? Isn't this a little bit different than a private club?
No, it isn't, because she, the performer, is making that decision that she has the right to discriminate. She has the right to choose who she wants to perform for. You can't force her to perform for people she doesn't want to. She is not depriving anybody of another show that's similar. It is not based on race or creed. This is a private gathering. That's why it's not discrimination. This is not to be compared to, you know, segregation or discriminating based on your color or your religion. That would be unconstitutional. This is constitutional because you do still have a First Amendment right.
It's unfortunate. It's unfortunate that when you are a part of, say, a white middle-aged male, for some reason you cannot be discriminated upon, it seems, in the public mind. But that is not what the law says. The law is clear. This was not a private gathering. It was tickets that were sold to the public. Not only that, Jesse, one fact that's important is they let these gentlemen in, made them sit in the back of the bus, if you will, like Rosa Parks, a reference there too. When they went to go get food, they came back and they were told, sorry, you're denied entrance merely because of your sex. And under California law, it's very clear. In fact, I'm looking at the Division of Protection of Civil Rights. Right on their website, it's called the UNRIC Civil Rights Act that was passed in 1959 that indicated that a public establishment open to the public cannot discriminate based upon sex, disability, national origin, ancestry, race, color. This woman does not have the right to say, well, I'm not going to discriminate on race, but I will discriminate on sex. Just as if a bunch of men opened up a same kind of theater on all male issues, opened tickets up to the public and said, women cannot come in here. It is a violation of the law, plain and simple.
Now, Jayne, in response to what Bob said, the idea of this law, this Civil Rights Act that was enacted, what would then be a situation where you'd say, okay, these men were discriminated against because a person who's looking at this case would say this is clear cut? What would be a case where they would be discriminated against?
This is not if they were black and you said that they couldn't come in because it's a white only and they're being discriminated.
But in terms of gender, in terms of whether it's a male show, an all-female show, an all-male show, what would be a situation then that would qualify as gender discrimination?
I can't think of one off the top of my head, but I can tell you, because I've been looking the other way, but I can tell you that there are women-only gyms for safety concerns, and that many states have women-only gyms, including California, which is why I don't understand this lawsuit either, because maybe that law from 1959 has been repealed or modified in some way. Look, we've had Augusta, Georgia. You know, we've had the Masters, we've had other situations where you sue for gender discrimination, where you're competing, where there's a money benefit, where you're being deprived of the opportunity to benefit in some way. This is not that case, Jesse. This is for pure entertainment and discussion of personal women's problems, issues. It's a safety zone for women only. Do you think that rape victims want to be with men perpetrators and that would be illegal?
You know, Jayne, you make an interesting point. This was a one-night-only Planned Parenthood benefit at the Largo in Los Angeles. It was described as a hybrid stand-up show, an interactive discussion between Eliza and the women in the audience aimed at giving women a place to vent in a supportive, fun, and inclusive environment. This was what was described on this website.
That's excellent.
But
I applaud that. I would love to see it myself. And in fact, the law entitles me the right to see it. I don't know how to say it any differently. When somebody says, I can't think of a scenario in which there would be gender discrimination, is the problem here. They see it with race. They see it if you're gay or you're not gay, but they don't see it with sex. And I can only read the words of the law because they are crystal clear. Discrimination by a business establishment on the basis of sex is against the law, period, end of story. So they're entitled to have their content and their women's forum and discuss all of those issues, but they don't have the right to exclude gay people, they don't have the right to exclude males, they don't have the right to exclude black people. Everyone is entitled to comment.
But isn't it possible that maybe these vendors who turned them away, they took the title of the show a bit literally? Maybe the intention of the theater, the intention of the production company, who was promoting the show, even Eliza Schlesinger, they never really wanted to exclude males from the show. Maybe wasn't this just a mistake?
Well, we don't know those facts. And in fact, that's a very good defense for her or anyone else who says we never intended to exclude the males. Maybe security did it, inadvertently. Somebody took it the wrong way. Well, then those people would be responsible. But the point here is that if a person is purposefully discriminating against a protected class, and that's what we call it, a protected class, and sex is, whether you're male or female, is one of those categories. If they're intentionally denied access to a public facility, you lose. Those who deny the access lose, plain and simple. And you can't have what's good for the goose, like I said before, is good for the gander. You can't have two sets of laws. Sex discrimination only applies to women. Racial discrimination only applies to black people. It's across the board. It applies to everyone.
This is not a matter of discrimination. This is not a matter of saying that you can't be, hired, you can't be fired, you can't. It has nothing to do with benefit. This is not the government.
You're not. It has nothing to.
Discrimination
listen,
in these cases.
I mean no disrespect, but those are not. That is not the criteria of the law. It says a business establishment, not the government. A business establishment cannot deny. And wait a second. Let me ask you: would you feel this? Would you feel the same way if there was a movie theater that said, we're showing a movie, and by the way, no women can come to that movie? Would you be saying that's not an act of discrimination?
That's not the same as what's going on here. And that's not charging and making money. This is Eliza Schlesinger wanting to perform and share intimate women's issues with other women.
Well, Eliza Schlesinger...
Let me give you an example. Bob, what would you think about a seminar for rape victims? Do you think that rape victims want to be in a room with men? Really? To talk about their experience of being raped by perpetrators?
Jayne,
do you think that a rapist was convicted has the right to come into that auditorium?
The fact that, unfortunately, in this world of an open forum and a lack of discrimination, you are not allowed to deprive people in a public establishment of the right to attend it based upon race, sex, national origin, sexual orientation. Period.
All right, guys. Stop. All right, I have a question. I want to ask Bob this, and this is it is. What they're suing for, I would imagine that shouldn't they just get the price of the tickets back? But what he's actually suing for is he's seeking compensation for costs incurred, including attorney's fees, in order for Ms. Schlesinger to undergo sensitivity training regarding sex discrimination, an injunction barring the defendants from engaging in unequal treatment of customers, and damages in amounts to be proven at trial. Isn't he asking for too much here?
Jesse, what amazes me by respectfully the question, and what I'm sure Jayne will respond to, is that is exactly what you ask for when men discriminate against women. It is a common standard set of demands as if we win this lawsuit, this is what we're seeking, and courts order it all the time. But for some reason, we seem to look at it and say, well, if a man's being discriminated, it should be different, the law should be different, the penalty should be different than when a woman is discriminated upon. They're basically in that complaint putting in what every man puts in discrimination.
Jayne, but isn't that a little much? Shouldn't they just, if they really had a problem, get the price of the tickets back? I think it might be a little bit much, but what do you think?
Of course, there are no damages. What are the damages here? The price of the ticket, which wouldn't even get him into small claims court, basically? I mean, it's absurd. This is somebody who just wants 10 minutes of fame for this exact.
Well, that's not accurate. Jayne, you know as well as I do, under civil rights litigation, for example, under 42 U.S.C. 1983, for example, when you're dealing with police, let me just finish this.
And talk to women.
Let me just finish the sentence. We know that many times the argument made by the defense often is, when there's police brutality, false arrest, well, what are the damages? And the damage is the civil rights violation itself. And they're not asking, by the way, for $1 million. They're just asking for the cost for the ticket and so on and so forth. But
sensitivity training?
But that is what is asked for in sexual discrimination cases all the time, and nobody would bat an eye about it if a woman was asking for it. If there was a group of men that got together in a public place and said that women could not come into that spot or into that location, and a judge found that they violated this very clear law in California, they would be asking for sensitivity training, and nobody would bat an eye, would they?
I have a question for both of you. This plaintiff, George St. George, as well as his attorney, Alfred G. Rava, they've been involved in cases in the past in very similar matters about gender discrimination. I wonder how much that's going to play in the fact that they have a history, at least, of filing these kind of cases, and will that come into play? Do you think that affects the value of their case? Jayne, what do you think about it?
It's credibility. I mean, it's, he's using this, again, as a public platform when the right here is of a private citizen. That's the whole argument here, Bob. This is not a public establishment argument. This is a private performance that she is going to render. This is not open to the public, and she has that right.
It was open to the public. And by the way, her rights end when she violates the discrimination law. Let's be honest. You know as well as I do, this law makes no distinction between sex and race. And if she were to have a performance for white people only, people like you and many others, rightfully so, would be screaming that that is a violation of the law. There is no difference under the law for race discrimination or sex discrimination. Just because she's a private person doesn't give you the right to violate the law.
Jayne, you were saying?
You didn't answer my rape victims analogy. Do you think that women have the right as rape victims to have a place, a forum, even in a public hospital, where they have a safe space? Because that happens everywhere, all over the world.
Jayne,
okay?
Jayne, I have a question.
It's not discriminating against men, but it prohibits men from participating in these kinds of seminars.
Jayne, here's my question. This keeps coming back. We saw earlier in 2017 that Lisa Durden appeared on Fox News, and there was a whole discussion about whether white people could be admitted to a Black Lives Matter only event. And it became an uproar about who was right and who was wrong. People might look at that situation and look at this situation and say, isn't this the same thing? How would you respond to that?
I respond to it because the people that are going to this, Jesse, to see Eliza Schlesinger perform and to interact with her and get her advice on the most intimate sexual issues and privacy matters that they have in their lives, they have a reason for going there. This is not to promote some social media blitz or for their own private agenda. This is for themselves. This is like going to a meditation for women only. Do you think that that would be discrimination?
The law specifically delineates.
Jesse, we're not surprised depriving men of the experience. Men could do the same thing next door.
But just so I understand, then it would not, in the sense they don't really have a right to attend these shows. I mean, if they wanted to attend these shows and they're denied being attended to these shows, let's say they fully support women's rights, or even if you had an all-male event. And I know that the attorney in this case has said, imagine if you had an all-male event in an Andrew Dice Clay comedian kind of forum, and a woman wanted to attend and she was denied. So is it the idea that if you are not part of that group, you do not have a right to attend that group? Maybe they are full supporters of women's rights.
You're focusing on the wrong person. The idea is focus on Eliza Schlesinger. She has the right to make a private performance with whom she wants, and to have an interactive discussion with whom she wants, and share her professional advice with those persons that she chooses under the First Amendment. Freedom of assembly, freedom of association. You cannot deny Eliza Schlesinger that right.
Bob wants to jump in. I can see Bob pouncing.
Come on, we know that all of those constitutional freedoms have limitations, and one of the major limitations to those constitutional freedoms is you cannot discriminate in the process of doing that. Now, this is not a private setting. Please, let's be honest with the facts here, straightforward with the facts. She opened this to the public. It was advertised on social media and websites. It went out to many people.
Women.
You had to pay a price to get in there. And in no way, shape, or form under California law can and it says right here, by the way, just curious, the places, establishments, bars, nightclubs, restaurants, hotels, motels, retail shops. If you were going to have an event in those locations and open it up to the public, you have to open up to all the public.
Bob, that deprives men the right to do it and to buy those items. Here, we're not depriving men of the right to assemble and associate and have these interactive discussions about their genitalia or their sexual issues. They can do the same thing next door. They're not being deprived of anything, and that's what you need. For
all right, guys. This is.
I just ask one thing, and I just want to make a personal comment. My whole career, I have listened to many people, including myself in particular, that have been told that we can't get jobs because we don't fit the right demographic of what people are looking for. And many people like me, that is middle-aged, white, paunchy, balding men, are getting to a point where we're like, it's okay to come right out and tell you specifically you're being discriminated upon, and no one says a word about it. We just have to take it. But if anybody were ever to say those same things to somebody in a more traditional protected class, like blacks or Hispanics or women, you would be put on the crucible of public opinion. But for guys like us, for men, white guys, everything goes. Those laws, even though they're there and say it's not right to do and you're not supposed to do it, people literally come right out and tell you it's being done, and there's nothing we can do about it. It's not right.
Jayne, final thoughts on that double standard argument, as well as what do you think what the future of this case is going to be? Eliza Schlesinger has said, since this is a legal matter, I'm unable to comment the specifics of this lawsuit. I will say that of the many shows I do throughout the year, Girls Night In was a singular event that encouraged women to get together, talk, and laugh about the things we go through, as well as donate some money to Planned Parenthood. It's unfortunate that this has now become an issue. So what are your final thoughts to Bob's argument, as well as what do you think the future of this suit will be?
I say again, she's not a government entity. She's not depriving anybody of any rights that they had. She has the right to share her private experiences amongst people that she is comfortable with, that she wants to help under Planned Parenthood. I mean, under Planned Parenthood, let's be honest, there are certain issues in our lives that are for women only. Childbirth is a woman's body, and yet men forever have been making decisions about what we should do with our bodies.
That is such a conflation of apples and oranges.
We'll get into this. We'll get into this.
That men have not ruled what happens with women's bodies.
Nobody's saying that, but you can't deprive a man. You keep saying that she's a private person and that the government didn't do it, but unfortunately that's not what the law says. The law says that a private entity, a private business, a place of public accommodation cannot discriminate.
Bob, final thoughts. Do you think this will settle? Do you think this will go to court? What do you think is going to happen?
I think it settles. I think he wins just like he's won, I believe, every other one that he's brought, every other suit such as this.
Well, it's interesting because, as I said, his attorney, who's a former secretary of the MRA group, the National Coalition for Men, he's filed more than 150 lawsuits in California challenging the practice of running ladies.
Coalition for equal people, men and women?
Well, as we know, it's a contentious issue. We have two. I'm not surprised that the person who's bringing the suit, this is somebody who's, I believe he's been the plaintiff in several suits challenging ladies' nights at bars and other public establishments. It's going to be an interesting case.
Jesse.
It's going to be an interesting case to follow in 2018. But I have to cut this short on this one because we have 3 more cases to go. Anybody who's been following, this is just the appetizer. As you can see, these two duking it out. It's pretty exciting. All right, both Jayne and Bob, stand by. We're going to be covering 3 more cases this morning. But in the meantime, what I'd like to do is play for you again. We are covering the Quinton Tellus trial because we believe in 2018 there will be a retrial of Quinton Tellus because there was a hung jury. What I'd like to play for you right now is the confusion that resulted at the end of this trial when the jurors were unable to determine a verdict. They were not fully able to understand whether a not guilty or guilty verdict needed to be unanimous. There was a question about what unanimity meant, and then also when the judge declared a mistrial. I want to play those clips for you, and when we come back, Jayne and Bob will debate another case.
I've been informed that the jury has reached a verdict in this case. My standard admonishment to spectators in the courtroom is that there absolutely be no outburst of any kind from anyone. There will certainly be no displays of emotion or anything of that nature. If it is, you will be promptly removed from the courtroom and further proceedings, and you will face the penalty of contempt. So please remember this is a court of law, and I would expect you to dignify that as best you can. I understand that this has been a very emotional time for families and loved ones in this case. I understand all that very perfectly. This court has a heart like any other person, and I understand both sides, both families that are involved and friends. I understand all of that. At the same time, I'm going to ask you and remind you to dignify these court proceedings accordingly. All right, if you bring the jury in, please. I've been told that the jury has reached a verdict. Is that correct? Did you all select a foreman? All right, sir. Let's see. Mr. Lampkin, is that correct?
That is correct.
All right. I don't need to know what your verdict was, but I just need to know, did all 12 jurors agree on that verdict?
Yes, sir, we did.
All right. Would you hand the verdict, please, to the court, to the clerk? Excuse me.
We all didn't agree on it.
Sir?
You said we all agreed on that verdict. We didn't.
All 12. The verdict has to be unanimous. So all 12 did not agree on the verdict? Is that what you're telling me, sir?
Yeah, I can agree he was in.
All right. I'd ask you to step back into the jury room, please. Pass the verdict, please, to the clerk that you have in your hand. Give them the jury instruction back. All right, court will meet with counsel in chambers. All right, bring the jury in, please. All right, once again, I've been informed that the jury has reached a verdict. Is that correct?
Yes, sir.
And I need to ask you if that verdict represents the considered judgment of all 12 jurors. In other words, is it unanimous?
Yes, Your Honor.
All right, has that verdict been recorded on a separate sheet of paper?
Yes, Your Honor.
Or would you pass it to the clerk, please? clerk please read the verdict?
We, the jury, find the defendant, Quinton Tellus, not guilty of capital murder.
All right. Any request of counsel?
Yes, sir. Request the jury be polled.
All right. I need my list. Thank you. It's been requested that the jury be polled. In other words, I'm going to start down here. I'm going to ask each one of you if that is your verdict. You just need to tell me yes or no. Okay? All right. Ms. Martin?
Not guilty.
Is that a yes?
Yes.
All right. Ms. Madison?
Not guilty.
McGee?
Guilty. I'm sorry.
Mr. Lampkin?
Guilty.
Mr. Johnson?
Jackson.
Jackson? I'm sorry. It says Johnson. All right, Mr. Johnson. All right, thank you. Ms. Felder?
Yes.
All right. Ms. Gauss? Ms. Boyd? Is that a yes, ma'am? All right. Mr. Jones?
Guilty.
Mr. Coleman?
Guilty.
Mr. McKinley?
Guilty.
Mr. Bullock? Ms. Bullock, excuse me. All right.
I'm way misunderstanding here.
I can't, I was having trouble hearing. All right. You may approach. It's very important we understand what your response is. And so I'm going to ask you to speak loudly so that I can hear you. The verdict that I have recorded here is we, the jury, find the defendant not guilty. So I'm going to ask you, Ms. Gauss, is not guilty your verdict?
Yes. Yes.
All right. Ms. Boyd.
Are you asking?
I'm asking you if you voted not guilty.
I voted guilty.
You voted guilty. All right. Mr. Jones.
I voted guilty.
All right. Mr. Coleman.
I voted guilty.
All right. Mr. McKinley.
I voted guilty.
Ms. Bullock.
I voted guilty.
All right. Ms. Martin.
Not guilty.
All right. Ms. Madison.
I voted guilty.
All right. Mr. McGee.
Not guilty.
Mr. Lampkin.
Guilty.
Mr. Johnson.
Jackson. Not guilty.
Ms. Felder. All right. May I see the jury instructions, please? It is very important that you all try again to reach a verdict, all right? Obviously, there's a split between you all as to the verdict in this case. I'm going to read you the instruction again. Give you some more time to deliberate. I don't know why the verdict was recorded as it was, but at any rate, I'm going to ask you to go back, consider your verdict, deliberate, and please record your verdict accurately, all right? I know that it is possible for honest men and women to have honest different opinions about the facts of a case, but if it is possible to reconcile your differences of opinion and decide this case, then you should do so. Accordingly, I remind you that the court originally instructed you that the verdict of the jury must represent the considered judgment of each juror. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you are convinced it is erroneous. But do not surrender your honest convictions as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Please continue your deliberations. You may approach. In order, we're going to stand just for a moment in recess. I may have another jury instruction to read you. All right, so just stay in our seats a moment. I'm going to put you back in your jury room, and I hope it won't be long before I send for you, but I'll send for you as soon as I can. Thank you. Ladies and gentlemen of the jury, I'm going to read you one more instruction, then I'm going to send you back to your jury room once more. And I want you to consider this instruction along with all the other instructions I've previously given to you. The court instructs the jury that all 12 jurors must agree on the verdict in order to find the defendant guilty. The court instructs the jury that all 12 jurors must agree on the verdict in order to find the defendant not guilty. If you are unable to reach a unanimous verdict as to guilty or not guilty, please advise the court in writing. All right. I will now send you back to your jury room for further deliberations. All right, we'll be in recess till the jury returns. I've been advised that the jury is ready to report. Is that correct?
Yes, Your Honor.
And that's been reduced to writing?
Yes, Your Honor.
How would you hand it to the bailiff, please? Clerk will read the verdict, or the report, I should say.
We, the jury, cannot unanimously make a verdict of guilty or not guilty for the defendant, Quinton Tellus.
In request of counsel? Defense?
No, sir, Your Honor.
All right. Ladies and gentlemen, that concludes your duties. I want to tell you how much I appreciate your taking the time and giving up your freedom to assist the citizens of Panola County in this case. It's a very difficult case. You've been very conscientious in your duty, and as I told you down in Pike County earlier last week, that I hold jury service in high regard, and I rate it right up there with serving in the military. And I hope that the next time that you're called, hope it won't be any time soon for you, but I do hope that you will take advantage of your experience and be willing to serve the people of Pike County again. I thank you for your service. I want to put you in charge of your bailiff, where you will be taken back to your homes today. Thank you very much. You're excused. The court will remain in order until the jury is excused. You'll bring the jury through, please.
I'm going to ask everybody to remain in their seats until the jury is finally discharged from the courthouse. Once that's done, a member of my staff will let y'all know when we can move to the outside of your vehicles. For the meantime, please just stand fast where you are.
The jury could not reach a verdict in this case, and it appears to the court that they were hopelessly deadlocked. Probably after 9 or 10 hours of deliberation, the court is going to officially declare a mistrial. And all right, thank you.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber, and thanks for joining us. As you just saw, that is the reason why we are covering the Quinton Tellus case from 2017, because it ended in a mistrial. And as we believe in this year, in the upcoming 2018 season, we believe that Quinton Tellus will be retried in that case. Again, the case of the brutal death of 19-year-old Jessica Chambers, who was burned alive. Really, really horrific case when you heard the description from the witnesses and the testimony that was brought out forward in that case and the evidence put forward. What this young girl suffered was really, really horrific. So when we come back, we're going to begin the whole case to show you what happened and why it was ultimately declared a mistrial. Again, in anticipation of hopefully there being a retrial in 2018. But in the meantime, we want to cover some more special segments. And if you heard earlier this morning, it was quite the debate between my two guests for the day. In-house right now in our studio is criminal defense attorney and former prosecutor Bob Bianchi. Bob, great to see you.
Great to see you, Jesse.
Great job this morning.
Thank you.
And also great job this morning was Jayne Weintraub, our criminal defense attorney, who is on Skype. Jayne, really, the both of you, terrific arguments. I don't even know where to begin.
This is what we do.
Well, let's talk about why kids shouldn't be tried as adults.
Well, that's a great point, Jayne, and thanks for bringing it up, because that is our next case that we're going to be talking about. This is a case out of Ohio. 4 teenagers have been charged with murder and 2 counts of vehicular vandalism after a man, Marquise Bird, was struck and killed by a sandbag that had been dropped from an overpass while he was driving in his car. Bird, who's 22 years old, of Warren, Michigan, was in the front passenger seat of a car traveling south on Interstate 75 through Toledo when a construction sandbag crashed through the car's windshield and struck him. He was the passenger. The driver of the car was not injured. A second car was damaged as well. And these 4 teenagers were arrested. Now, it should be just noted about this victim. Bird's cousin, Shavante King, told the Toledo Blade that this 22-year-old victim was engaged to be married, and he had a 1-year-old son. He had been on his way to meet friends in Toledo when this accident occurred, or when, I should say, this alleged crime took place. He's been described as young, energetic, outgoing, and lovable. Really, really tragic to hear. Bob, I want to start with you. These 4 teenagers, what is the evidence against them so far that we know?
Well, what we know is that these 4 teenagers are alleged to have been on an overpass. And by the way, this is really odd because I've handled a number of these cases as a prosecutor. I don't know if this is like an epidemic going around the country, but they were throwing things off. There was another incident where they had thrown apparently a 6-pound rock off the bridge, and that did not, it caused some vehicular damage, but it didn't cause any injury. And then they had thrown a sandbag that was at a construction site, and it had not been covered, the bridge, and it went into the traffic, and it hit the passenger, and unfortunately days later he died as a result of those injuries.
Jayne, how do we know it's them?
There is an eyewitness, and I believe there is an admission from at least one of the kids.
And what do you think about their case so far? I know you think you have some strong opinions about these teenagers who were arrested in connection with this crime.
Here's what I think, Jesse. It's the overall picture of treating juveniles as juveniles, or should we treat juveniles as adults? It's an age-old discussion. The United States Supreme Court a couple of years ago has struck down, eliminated the possibility of juveniles from receiving the death penalty in murder cases for a simple reason that applies all the way across this board. And that is, someone's brain is not fully formed scientifically, evidentially, and from an evidentiary purpose and morally until they're in their early 20s. So we're not going to execute juveniles for their activity from when they're under 18, and they don't even have the ability, as we do as adults, to understand the consequences of their actions in the same way. And so similarly, I say that law should apply across the board. It's not a matter of what the evidence is in the case. The matter is, should the case be in juvenile court or adult court? And I say it belongs in juvenile court. You're talking about a 12 and 13-year-old kid here. I've represented a 12-year-old kid charged with murder who was sentenced to life imprisonment in adult court, Alex and Derek King in Pensacola, Florida, 10 years ago. And you just throw away those kids' lives. Yeah. Thankfully, we were able to reverse it. We were able to get them back into juvenile court. They were sentenced by the Department of Juvenile Justice. It's not an excuse for these kids. These kids were punished. They were in custody for 7 years before they got out. It's giving the kids a life. It's not giving up on a 12-year-old who throws a sandbag over a bridge at a car.
Now, Bob, here's the question to that. I mean, couldn't the argument be that if they knew what they were doing, and they've have the ability to form that choice, that action. And again, we're assuming that they did this. Obviously, we don't know everything as of yet. But couldn't the argument be that if you are able to create that choice and you know what you're going to be doing? I think the law in Ohio is that a child is defined as a person under age 18, can be tried as adult only if the child was age 14 or older at the time of the offense. So when you're looking at a 12, 13 versus a 14-year-old, how do you make that distinction, and is it enough there?
Okay, wow, there's so much meat on this bone, Jesse. So first of all, my understanding of the facts are that there was one 13 and the rest were 14. That was my understanding of what occurred in this case. As to the 13, it is correct. One of those juveniles would, by law, not be able to be tried as an adult, but the others would. Now we get into prosecutorial discretion. Having been the person who had to make these actual ultimate calls, and as a former homicide assistant prosecutor, many people are very liberal about these ideas of brain development and brain formation until their daughter or their mother or their father or loved one is brutally murdered in a purposeful way. Now, I said purposeful way. I, as a prosecutor, authorized juveniles being tried as adults, for example, who murdered and dismembered a body of a girl very willingly, very calculatedly, and that was, by the way, after they beat her with poles and pipes. That mother, who was probably a little bit of a liberal person and didn't believe juveniles should be treated as adults, had a very different opinion after we recovered her daughter's body parts from the river where she was dumped. That said, that's not this case. This case is more of a situation, probably, as we know the facts right now, of some stupid activities by juveniles that probably didn't intend somebody to die, despite the fact that it was extraordinarily reckless. And the prosecutor in Ohio, as I understand these facts, has said, we are not going to try them as adults. We are going to keep it in the juvenile court. At least that's the information that I have. And I believe that that is a proper prosecutorial activity, because the person who dismembers and beats a person at 14 years of age is different than kids that throw sandbags off because they're being stupid. But let me just say one last point. I have never had a murder case of an adult or a rape case of an adult, or many people that come through the criminal justice system, as I'm sure you know, that don't have some form of mental illness or addiction. Most of them do. And it is true that with juveniles, our idea is to rehabilitate them, and with adults, it's to punish them. But there are certain circumstances in which juveniles represent a continuing danger to the public and need to be tried as adults. I just don't see it in this case.
Jane, what do you think about what Bob's argument was?
You want to warehouse 13-year-old kids for their malicious, say it was a malicious, vicious act. This is not a liberal Baja statement to say that the brain is not fully formed at the age of 13, 14, 17, or 18. It is not a humbug fact. It is a scientific fact that the United States Supreme Court believed. It is a fact, scientifically based, that the judgment of a 14-year-old kid is not the same as the judgment of a 25-year-old person. That's why they are called kids, and they are juveniles. That's why we don't let 13 and 14-year-olds drive trucks. That's why we don't let 13-year-olds make decisions or be in the military or do life-altering activities in our country that bears responsibility, because they are juveniles. They don't have the capability mentally to make the same judgments that we do as adults. And stop comparing what the victim was like. This is not about the victim. Let's presume in these cases the victims are all innocent victims. Pretend it's a drive-by and not the Sandbag, where somebody is shot with a gun in a drive-by drug deal. The victim is always innocent. In a DUI manslaughter, the victim is always innocent. Don't confuse justice with revenge. You know, we're not seeking retribution in these cases. We're seeking to punish someone for their actions if they're found guilty.
What's the difference between punishment? I'm sorry, I'm confused. What's the difference between punishment and retribution?
When you punish someone for their activity, you don't punish somebody in a way that you're just going to warehouse them for the rest of their lives and take a 14-year-old kid and just throw them in a cage.
No, see, that's an excessive argument. No,
rehabilitation.
No one is saying that you're going to warehouse them for the rest of your life. See, these are the conflated talking points that aren't realistic in a courtroom. And let me tell you something. One of the things that you said, with all due respect, is one of the problems here. The victims do have rights. The victims do have a right to have justice. When somebody is killed, let me just finish the sentence. Let me just finish the sentence. I gave you an opportunity to finish. Let me have the opportunity. What I was trying to say there is that I have met through my career as a prosecutor, both as an assistant prosecutor and the head prosecutor, many people who have a differing point of view when it's their loved one that's killed. They don't care about brain development. They don't care about the immaturity or maturity. And the Supreme Court merely said that they couldn't.
To make the judgment and the
Wait, I have a question. I have a question for both of you.
The Supreme Court said, well, just one thing, Jesse, because I'm having a hard time hearing. The Supreme Court said that those juveniles could not be executed. It did not say they could not be prosecuted as adults for murder. And not every juvenile should be. We should take into consideration their immaturity. We all mature as we get older. And even when adults commit murder, as a prosecutor, I have taken in mitigating information or circumstances that would tend to justify the conduct and making a decision as to what the punishment would be. But in certain instances, there are juveniles who would do such atrocious things that justice, deterrence, requires they be incarcerated.
Jayne, here's my question. Why do we have this disparity among different states? So, I mean, in October, prosecutors in Michigan said that 5 teenagers would be tried as adults after being charged for murder in an incident, same as this, where a passenger was killed by a rock that was thrown over Interstate 75. They face a potential life in prison. Why do we have this disparity?
And it's a shame because 28 states in our country routinely charge 14-year-olds routinely as adults. And I hate to say mine is bigger than yours, Bob, but I also was an assistant state attorney under Janet Reno for 8 years, and I also prosecuted homicides, and I was the head of juvenile, and we made these decisions day in and day out when I was a baby lawyer and a prosecutor, probably with not as good sense as I have now. Why? Because now I've seen the system from both sides.
Well, with all due respect, ultimately, you can work underneath somebody. You can work underneath somebody, but when you're the person ultimately responsible, the person that the government has placed as the person who makes
I understand.
Wait, let me just finish. That makes the ultimate decision, and I have to be the person, singularly me, as to what I'm going to do with a particular case. There are some juveniles, most of which I did not prosecute as adults. But there were some juveniles that not only were so atrocious in what they did and had such a lack of remorse that I had to be concerned about
such a mental defect?
Madonna me. In Italian, we would say, let me just finish a comma. The thing here is, listen, the point is that I have to be concerned about something that you know is very real. You were a prosecutor. You know this. What would you do and how would you feel as a prosecutor if that person went out and committed another murder after that? Would you have the same feeling like, oh, well, the brain isn't formed yet, so let's give them yet another break?
Jayne, what were you saying?
Are you saying just put him away for the rest of his life?
I did not say that.
You're always taking a chance. But when we deal with juveniles, and by the way, Bob, the United States Supreme Court, when they said in the decision that we will not execute the kids anymore, what they said, and I'm quoting to you, is they should not be held accountable to the same extent as adults because of the clear lack of moral judgment.
And most times they're not.
So what I'm trying to reinforce is, in most of our states today, it's very popular to say what Bob is saying. Try them as adults, look at the activity, but you're not looking at their prior history.
You're not taking.
Wait, Bob, I want you to address that. Jayne, I want Bob to address that in a minute, but this is a question to both of you, and we're talking about the ages, and as Bob said, there's 3 13-year-olds and 1 14-year-old. Mm-hmm. Because of this disparity in terms of the ages and in terms of what might be appropriate to trying them in adults or not, and we talk obviously this conversation about mental development, is there a situation where you would see maybe the 3 defendants pointing the finger at the older boy or the older teenager and saying, we were influenced by him or her, and that's a situation by the older defendant? Is there anything like that?
That's a legal strategy.
Jayne, we're going to get Bob, and then I want to hear your opinion.
Yeah, I think this is a great question. The question becomes in these cases, to what level did those juveniles participate in this activity? Because just being merely present may be a very good defense for them. In other words, my responsibility was I was just there. I didn't do anything here, and that would be a great defense. But I have to address one thing that Jayne had said earlier before. I did not say, and I was being very specific in saying, that when you're treating them as an adult, a juvenile, in a heinous murder case, does not mean you have to put them away for the rest of their lives. It could be something less. And in fact, you know this as well as I do, Jayne, that when the judge is sentencing as an adult, they're going to look at aggravating and mitigating factors. And one of the mitigating factors that every court in the state, in every state in the United States looks at is youth and the ability to be rehabilitated and the fact that their youth contributed to the crime, which usually leads, even when being tried as an adult, to a significantly reduced sentence. So I don't, what I'm just saying here is that some cases warrant the juvenile being tried as an adult with maybe a more severe sentence than a juvenile court, but not as much as you would, for example, a 25-year-old premeditated murderer who did the same thing.
I don't know what state you're in, but I can tell you in Florida that will not happen because there's a mandatory minimum sentence that cannot be waived if you're found guilty of first-degree murder in adult court. You are sentenced to 25 years, no parole, no pass go, no juvenile, anything. You're supposed to be housed separately, if it's possible.
If you're convicted.
And Jayne, question. The question I posed to Bob, the idea that there's a difference in age between the 13-year-olds and the 14-year-old. If there's I don't believe they're going to be defended by the same attorney. I don't think that would happen. If they're going to be separated by different attorneys. Is there a way that you would say, okay, we're going to point the blame at the older defendant?
Well, first of all, you can't just say that. It depends what the facts and the evidence are. That's one thing I think Bob and I will agree on. Definitely. But the good point that you raised, Jesse, is there is proportionality to defendants, and that is a whole strategy, for example, in death penalty work, where if one defendant is disproportionately treated by the law, in other words, if one becomes a flip witness against the other, then there will not be, and he gets, say, 10 years in prison, you can't seek the death penalty on the other. It is so disproportionate that the law is not going to permit that, and that is across the country. So that's a very good point that you brought up. It will go to a defense, as Bob was saying, whether or not there was mere presence, if the kids were just merely present, or one was more active than the other in the actual criminal act.
I mean, like, who's the person?
Real facts were.
Who planned it? Who plotted it? Who's the one who actually threw the sandbag off? These are all very relevant factors.
And it's still in the early stages, and it is a case that we will be following in 2018. I think at the end of the day, everyone here can agree that these incidents just happen way too often. And it seems to be, whether it's a hobby or some sort of habit that really should be stopped, and it's horrible to talk about. I wish we had a little bit more time to talk about this case, but we do have two more to cover today with our great guests today and hear them debate it out. So stand by, Bob and Jayne. We are going to come back to both of you to talk about two other cases. In the meantime, I want to play for you right now the prosecution's opening arguments in the Quinton Tellus case. Again, we are replaying this case because we are talking about what to expect in 2018, and we do believe that Quinton Tellus might be retried for the murder of 19-year-old Jessica Chambers, that horrific story of this young girl being burned alive. So I want to play for you the prosecution's opening arguments and hear how they laid out their case.
That will not be available to you. So the one thing that not only do we ask of you, and I'm sure the defense lawyers will ask of you, is to please pay attention and please listen to what these witnesses are going to say. I anticipate that we're going to have somewhere in the neighborhood of around 35 witnesses. We've been working really hard with the defense team over the last several months, and we were able to whittle the number of witnesses down from a much higher number to where we are now with some things that we have stipulated to which Judge Chatham at some point will read you what those stipulations are. Okay? I want to start by telling you that on December the 6th of 2014, Jessica Chambers was a beautiful, blonde-haired 19-year-old. She lived in a community that's about 6 to 7 miles due south of here called Cortland. Now, Cortland's like a lot of communities I'm sure you have in Pike County. that there aren't many people there, and basically everybody knows everybody. And that's the way that Cortland is. It was back in those days, and it still is today. A very small community. About 2 weeks prior to December the 6th of 2014, Jessica met a man that would eventually end her life. She met a man that would change the course of her family, that would change the course of the rest of the life of her family and her friends and everyone that knew her. And that man is Quinton Tellus. She met Quinton through a young lady you'll hear from here in a little while named Keisha Myers. And Jessica and Keisha and Quinton were all friends. They hung out together. Not a lot. And you'll hear Quinton tell some officers in some statements that he made that they would ride around, which is common. I mean, I remember when I was growing up, when you're living in a small community like Oxford back in those days, that's what you did. You rode around. Just not a lot to do. And I'm sure all of us at some point in our lives did the same thing in these small communities. And Jessica, on the morning of December the 6th, woke up. She called Quinton Tellus and said, "Hey, we'll get together." She picked Quinton up at a place, well, at his residence, which is, there's an area there. You'll see that when we go out on the field trip to show you the areas that you're going to hear about. You're going to hear about a lot of these areas from me here in the next few minutes. But on Highway 51, which runs right out of here and heading south, runs into Cortland. And at Cortland, there is a store called M&M's Grocery. M&M Grocery has video cameras. Across the street from M&M Grocery is the residence of Quinton Tellus's mother. In front of that residence is a shed. And it's near Highway 51. The residence that I'm talking about is just the driveway runs right off Highway 51. The cameras from the store actually show the driveway where Quinton lived and also an adjacent driveway, which will become important in this case later on. So Jessica picks up Quinton at his residence, and they begin to ride. And remember, this is Saturday morning. They go to Keisha Myers' house, which is not real far away, and they pick Keisha up, and they ride around, probably around 30 minutes. But one interesting thing that Quinton Tellus told the officers when he was interviewed was that they went by the scene where Jessica was found twice. It's a very remote scene. And I'll get to that in just a minute. As I want to take this as chronologically as best as I can for y'all. They ride around, and eventually Quinton gets out of the car back at his residence, and Jessica goes home. You will hear her mother testify, she'll be our first witness, that Jessica came home and took a nap, and that she woke up late in the afternoon, and she began to call and text Quinton. The one thing I want you to keep in mind is that she was also trying to get a hold of her friend Keisha, because Keisha will tell you that they had plans for that Saturday night. And December the 6th was a Saturday. But she couldn't get a hold of Keisha, and Keisha will tell you that she had one of those minutes phone where you have to pay for your minutes, and that she had run out of minutes, so her phone wasn't working. So Jessica was unable to get a hold of Keisha to find out what they were going to do and where they were going to go. So she contacts Quinton Tellus. And Quinton picks her up, or she picks Quinton up around 5:30 in the afternoon, and they begin to ride again. And they end up in Batesville, right here where we are now. As y'all came in yesterday, I don't know if you noticed, but there was a Taco Bell and some restaurants right as you got off the interstate, right near the interstate area. They end up going to Taco Bell and getting some food. They then drove back to Quinton's house. Now, Quinton will tell you in the statement that he gave the police that they parked in his driveway. But the cell phone data, which I'm going to get into here in a little while, shows that they were at an area just south of his house. And you're going to hear some terminology called RTTs, cell site location, cell location data. And we've got an expert that's going to explain all this to you, and I'll give you just a little bit about what that means right now. As we're sitting here, if you're not using your phone, it is sending a signal to the tower, if it's on, kind of just telling it where it is. Okay? Now, there are towers all over the place here in Batesville, so when we try to get cell site or the location of the phone, it's a lot more accurate because there are more phone towers here in town. As you get into Cortland, depending on who your provider is, you might have only, and there was a tower in Pope, which is just south of Cortland, and there's a tower in Batesville that controlled AT&T. All right, Verizon actually has a tower in the Cortland area along with the towers in Pope.
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber. You were watching the opening arguments in the Quinton Tellus trial. This is the case of the murder case of 19-year-old Jessica Chambers, who was burned alive. We covered it this past year. It ended in a mistrial, and we believe in 2018 Quinton Tellus will be retried in connection with that case. Will the prosecution adopt the same strategy or maybe a different one? Well, we're replaying a lot of their clips from today, including the prosecution's opening arguments. But right now, I want to continue on with our special segments for the day. Again, I'm joined by two great guests. They've been battling it out all this morning. I'm here with Bob Bianchi, former prosecutor and criminal defense attorney, as well as Jayne Weintraub, criminal defense attorney out of Florida, who's on Skype with us. Both of you have been tremendous today, and this has been quite a few good debates.
Yeah, love it.
So let's go on to the next one. There is a new service right now out of Oklahoma City. It is a service that promises a free DUI attorney for offenders in exchange for a baseline fee starting at $20. It's called the DUI Warranty Option 2 program. Now, Jayne, I know this is not an ideal program to defend, but you're a great defense attorney, so I'm going to put you in the hot seat. Isn't it seem a little unethical in a certain way? I mean, prepaying for legal services you may never see. What do you think about it?
Well, no, you know, the concept, I'm going to forget the fact it's for a DUI. The concept in and of itself is not new at all. I mean, teachers' contracts have it all across the country. They give you prepaid legal contracts with certain law firms or lawyers that have agreed to work for the union rates for very reduced fees. It's the same kind of a concept. And here, I guess there's a need for it, or the insurance companies, you know, don't want it, or I don't see a problem with it. I just find it abhorrent that a lawyer would work for $20.
Yeah, Jayne, I want to follow up with that. Again, I like to believe all lawyers are equal in terms of knowledge and skill base, but $20? What kind of lawyer are these people getting?
You know, it's not really that the lawyer will get the $20, Jesse. I think it's that they pay a fee to the company for $20, and there's an aggregation of that money that then goes to a lawyer, because how often is that fee going to be used? You know, the $20 membership fee.
Let's get the opposite perspective, Bob. Isn't this a good thing? Isn't this a good thing? I mean, doesn't everyone have the opportunity to be represented well-intentioned people pulled over for DUIs all the time? I mean, isn't this program a good thing?
It's a disgrace.
Okay.
And it's part of a slippery slope in the legal field of advertising that is predatory and does not assist the client. Now, when I sit down with a client, as I'm sure Jayne does as well, because she's a very squared-away attorney, as are most of us, you have to know the facts and circumstances. With this prepaid service, it's like a menu. It's like a Chinese menu. Oh, if you just want a lawyer, it's $20. If you want a jury trial, it's extra. Well, how does a consumer know whether they're going to need a jury trial or not need a jury trial until the lawyer has had an opportunity to review the discovery, the police reports? You know as well as I do. They say it right on their website. A lawyer representing in a DUI case could cost $5,000 or $10,000 because a good lawyer is going to review all the facts, all the circumstances. He's going to present the defense. But if you don't check off the right box prior to the incident happening, you could be shafted. And by the way, I'm sorry, just one last thing.
No.
Who is this lawyer?
Yeah.
Well, I don't even know what this company is. Are these lawyer people? They tell you don't have the right to choose a lawyer. We'll give you one. And any lawyer or any company that's doing this is doing it on the cheap. And what that means is they're not doing qualitative work. It's predatory. It's disrespectful to the legal community. And people that are being bamboozled into paying this money, I guess, deserve what they get.
Jayne, what's interesting, what Bob said, is that if you also look at the website, it says if a purchaser's arrested for a DUI and the cop finds cocaine in your car, this warranty doesn't cover an attorney for that charge. Or if this person's involved in a motor vehicle accident and someone's killed, the warranty doesn't cover an attorney to cover the homicide charge. As Bob said, it kind of seems like a Chinese food menu. What do you think?
Well, it really isn't. It's saying that we want to be very, very clear. We're only going to represent somebody for a plain DUI, not a DUI manslaughter when there's a death involved, and not a large cocaine case, which is, a felony or could be drug trafficking or a whole other animal. This is like a flu shot in the legal field, a DUI. And so if somebody wants to prepay that, I don't think that there's a problem with it. And even though I don't ever engage in any kind of advertising, I don't think it's sleazy, and it is perfectly legal, especially, I look at any of the billboards around this country about PI lawyers or criminal defense lawyers, or look at websites. It's all advertising. So to say it's sleazy, it just isn't accurate. But I just don't have a problem with it.
Well, Bob, let me ask you, what's the difference between this and if somebody can't afford an attorney and one's appointed for them, a court-appointed attorney, the idea of choosing who represents you in both kind of cases isn't the same thing?
Well, no, it's different because many people have a problem with court-appointed attorneys and don't believe that those court-appointed attorneys, based upon the
giving them the benefit of the doubt.
Well, no, I mean, some of them are excellent. I've tried cases against court-appointed attorneys that are just excellent lawyers, but sometimes they got 300-400 cases that they're dealing with, and they can't put the quality and time that's necessary like a private attorney.
And everybody can afford a big shot lawyer, Bob.
Wait, Jayne, Bob, what were we saying?
Like myself or Jayne can provide. However, the Supreme Court of the United States has indicated that all people are entitled to representation. So the public defender's office at least is vetting these attorneys. There's a system. The government is involved in monitoring it, and they have to comply with all ethics rules. Listen, when I look at this thing that sits here and says, this to me was the key point, do you want the plan to cover a jury trial? This is a very, very complex decision that we lawyers have with clients, whether or not they should have a jury trial or not. It's like me going to the diner and saying, a salad, do you want a jury add-on? Do you want extra chicken? Yeah, throw some extra chicken on that. But what if you don't? How can a client possibly, and Jayne, you know this, how could a client possibly make a determination prior to something happening whether or not they want a jury trial? Now, and if they don't check that box off, yes, then what happens?
Jayne, what do you think about that, in the sense that, again, as Bob was saying, you won't know that unless you're represented by an attorney who can give you some advice about a jury trial or not?
I'm sure that, maybe that's a glitch in the new program that was just instituted. You bring up a good point, Bob.
Now, let me ask you both.
Not the date and time that I'm going to agree.
But Jayne, don't they defend themselves? Or maybe I should ask Bob this. Don't they defend themselves? You asked what kind of company is this? Well, they said, look, this is option 2. Option 1 is call a friend. Don't drunk drive. Call an Uber. Aren't they protecting themselves here? Doesn't that seem like a right thing to do?
This to me is not an issue of protecting themselves. This is an issue about ethics and attorneys. And God knows we have enough problems with ethics and attorneys. We don't need these Uber websites that really drive people to these ridiculous plans with a lawyer. You don't know who you're getting, whether they tell you we could choose any lawyer we want. What are you going to do if you're charged with a crime, or if you're charged with a DUI, or you may want a jury trial? I bet you that these are kids coming out of law school that have no experience, or people that have problems.
They're very good lawyers,
the point of the ethics rules is that the skill of the lawyer should be what drives the marketplace, not advertising. Now we've just taken it to a place where you don't even know who the lawyer is on the website. You just get whoever they tell you're going to get. They should not allow this.
You're in the jury box when you're arrested in arraignment. So let's be honest. Not everybody can afford a lawyer.
Not everybody can afford a lawyer.
And if you can't afford an attorney, you could fill out a 5A or a form similar to that, where you have the services of the public defender, or in some jurisdictions where they have already vetted attorneys that have a reputation, have experience, have background, and that the court will pay for it. My problem here, Jayne, is that why aren't they saying, hey, if you get a DUI, we'll handle your case for $20?
It's a bet that they're making. It's just a bet. It's a bet on the business that they will get so many people.
And it's a gamble for the clients.
It'll be worth it for them. It's a business decision. It is not unethical.
Well, first of all, we can debate whether it's ethical or not, and this will be something that will be looked at, because attorney advertising, as you know, in all of the states is much different than advertising for a regular business. There has to be complete candor, full disclosure to a client who has to understand all of the risks and consequences and who their lawyer is that will be representing them. None of that is represented in this agreement.
I think
you just don't want the competition, Bob.
I don't. Hey, listen. I don't have to worry about the competition, because here's the thing: these websites, not just this, all these websites with these deceptive practices, with these people saying that they've got experience that I know for a fact that they don't have, is in fact taking business away from the qualified, decent lawyers that have ethics and are doing a good job for their client. You're not going to compare me. You're not going to compare my DUI experience to a kid that just graduated law school for $20.
Listen, I think that this case...
There's no basis in fact to say what kind of lawyer would be defending this to get...
Well, you tell me, Jayne, you tell me then.
Hired lawyers and they
tell
just
me,
want something to
how do you know that? How do you know that?
You shouldn't be defaming somebody that you have no idea.
I'm not defaming anybody. I don't know who it is. How
All right,
can I defame
guys.
an unknown person?
All right, guys. Listen, this one is going to be debated, particularly in the legal community, for some time. I'm curious to see if it'll pop up in other places, depending upon the success in Oklahoma City. And hopefully we'll have you guys back to talk about that. We do have one more legal case to talk with our two attorneys here for the day. But we're going to take a quick break. We're going to show you a quick continuation of the prosecution's opening arguments in the Quinton Tellus case. And when you come back, we're going to talk about a first date gone terribly, terribly wrong. Take a look at this.
Okay, and it's easy for experts in cell phone analysis to be able to determine where you are, maybe not precisely where you are, but within a general very close range based on the signals that your phone is sending to the tower. Now, every tower has 3 120 degree. Everybody knows a complete circle is 360 degrees. The towers are broken into 120 degree segments. Okay? So when these cell phone experts are able to look at the data they're getting from the subpoenas that we did in this case, they can tell you what tower and what sector that phone is actually located in. Okay? You're going to hear all of this about it, and I've gotten off the beaten path a little bit. But when I said a minute ago that the cell phone data was showing that they really weren't at Quinton's house, but a driveway that sits next to his house that leads up in the back to a trailer. Okay? We knew who lived in that trailer, and it was a friend of Quinton's sister, and his sister stayed there sometimes. So we know where all the parties are located, and all of this is also covered by the cameras that are located at M&M's. All right, everybody following me on this so far? So we know that around 6:30 that Jessica and Quinton's phones are both hitting at a site just south of his house. We know that at 7:26, we're going to show you the video. Now, it's dark and you can't see the cars, but you can see the lights. That at 7:26, a set of headlights leave that driveway area and turn south on Highway 51. We also know that at the exact same time, Jessica's phone begins to move in that same direction. If you go less than a mile from his residence and his or the driveway next to his residence, if you go less than a mile and you turn back to the west, you're on what they call Main Street in Cortland. And you go due west, and Main Street turns into what they call Heron Road. And there's a site on Heron Road where there's a gate that leads back into some hunting camps. And we all know, and I'm sure they got them all over Pike County, you got hunting camps that folks like to go to when deer season starts and things like that. It's very similar here. There is a hill on the bank of that drive leading into...
Welcome back to the Law and Crime Network, everybody. This is Jesse Weber, and thanks for joining us. We are replaying clips from the Quinton Tellus case from 2017 because we believe in 2018 Quinton Tellus will be retried. His first trial ended in a mistrial, and we believe he will be retried in connection with the death of 19-year-old Jessica Chambers, that young, really tragic story, this young girl who was burned alive. Really sad story, and we are replaying clips from that trial all day today, and we'll talk about it in a little bit. But right now, I want to continue on with our final case for this morning with my two attorneys for the day, for this morning, criminal defense attorney and former prosecutor Bob Bianchi, and via Skype, criminal defense attorney Jayne Weintraub. Okay, guys, this is the last case. Not even more of a debate, even though you guys had a great debate this morning. This one's a little weird. What do dating, Andy Warhol, and getting drunk have in common? Well, it's a very, very bad first date. A woman from Texas, Lindy Lou Lehman, you see her right there, met a prominent local attorney, Anthony Busby, for a romantic evening. But by the end of the night, she'd been arrested on felony charges of criminal mischief. Apparently, the two returned to Busby's home, but he had called her an Uber because she was so intoxicated. She refused to leave, went on a rampage, screaming, "I'm not leaving," poured red wine, and tore down paintings, including two original Andy Warhol paintings. She's been accused of throwing and shattering two sculptures as well. We believe the report is now up to $1.5 million in damages. We believe the damaged Warhol paintings themselves were each valued at $500,000 in court documents. I'm laughing about this, but Bob, dating's complicated, huh?
Jesse, I don't even know what to say. I mean, like, unfortunately for me, when anything got damaged in mine, I didn't have enough money that it made a difference. But this is obviously a bad night. And the really strange thing about this case is apparently at some point in time, he said he didn't even know who she was. So somehow this woman wound up in his house drinking wine, drunk. He's ordering an Uber. She's hiding. She won't leave. She winds up throwing wine on things, ripping things down. I feel bad for the guy because he had his house damaged or whatever. But, you know, any one of us can relate to a bad first date, but this is a whopper.
Jayne, let me ask you the $1 million question here. $1.5. Second date? Second date for this guy?
I don't think so. The facts are really funny and we're laughing about it, but you never know. Why is she jumping around? Is he chasing her? Where did he meet her? Does he know that she's drunk and inebriated when he brings her home? Doesn't he have some responsibility here? Just saying. I mean, who brings somebody totally sloshed back to their home late at night unless, you're going to take advantage of them? Just saying.
But that's a good point, Jayne.
And paintings are insured.
That's a great point. The fact that, isn't it kind of like buyer beware? If you bring somebody back to your apartment, a complete stranger, aren't you kind of responsible a little bit for what happens?
Well, you know, you wake up the next day with the buyer's remorse, but I mean, I don't think that you expect that you're going to be physically violated. Your house is going to have wine thrown all over it. Your Warhols are going to be, not that I've ever had one, are going to be ripped down. And it's just going to be a real calamity and a nightmare. What I'm curious about, I think there's more to this story, Jesse. Like, why weren't the police called? How did she get there? I agree with Jayne. Like, what were the circumstances? There's something else that went on here that caused this person, I would imagine, to go, you know, off the deep end. Not that it may justify what she did, but there's more to the story.
Well, Jayne, isn't it funny? I mean, this guy, Anthony Busby, he's a prominent local attorney. I mean, he must have done very well for himself to have at least $1.5 million in damage. I mean, he has these Andy Warhol paintings. This guy did pretty well for himself.
Or it was inherited, or it was a gift. I mean, we don't know. And that's just adding presumption on presumption and speculation, but even so,
let me ask you this:
It just shows he's a jerk. And he had bad judgment when he dated her. He had bad judgment when he brought her home, and it's kind of like assumption of the risk to me.
I agree with you.
Her in, she's not trespassing, and who's to say that it wasn't expected based on? We don't know what her side of the story is. We don't know what she's going to say he did that precipitated her throwing the wine on the painting.
Jayne, you mentioned this earlier. Does insurance cover any of these damages? How does it work?
Sure. I mean, I don't know. I'm not in the insurance business, but I would assume that's why you have insurance. Bob might know the answer.
I'm actually,
you'd have to insure.
The answer to that is insurance would cover it. I'm just wondering, he may be the founder of that $20 DUI website, so maybe that's why he's got all that money.
Well, what do you think will ultimately happen to her?
Well, listen, I go back to my prosecutorial point of view again. Of course, we need to know more facts and circumstances, but we understand she was drunk. That's a mitigating factor. There's obviously something that got her extremely agitated to cause her to do it, but by the same token, there's a significant amount of criminal mischief damage that's done here. So it wouldn't be the kind of situation in which I, as a prosecutor, would look to put somebody in jail, because to me, she's either intoxicated and or mentally ill. But, you know, so she's just going to have to pay some price. You just can't let people go into somebody's house and destroy it.
Jayne, what do you think?
I think nothing's going to happen to her. I think when she gives a statement or when she has a lawyer that comes out and speaks on her behalf, we'll know what happened. And to me, it seems like something precipitated that kind of activity. Maybe she was running to get away from him. And if so, then there's a whole other investigation that needs to happen. You know, this is Texas, and criminal law in Texas is something you can never predict.
Yeah, but you know what? When you're running away from somebody, that's a great point. I mean, we don't know what happened. She could be a victim of a crime, but you typically don't start throwing wine on paintings and ripping things off the wall when you're fighting for your life or that you're a victim of a crime.
What do you think happened to the studio, Bob? I tore this whole place down. That's why they had to rebuild it. But no.
Jesse.
Well, thank you. We have a great team here who did it. But honestly, the truth is, love, you know, love is complicated. It's not love. Again, the guy brought her home the first date.
He may like it. Who knows?
Who knows? But I have to thank both of you for joining Bob Bianchi, Jayne Weintraub. You really provided extremely, very insightful points to the cases we covered today. Really terrific debate between. I think you guys are still friends after all this.
Absolutely, great debate.
That's what lawyers do.
That's what lawyers do. So again, we thank you both for coming on, provided great analysis, and we can't wait to have you both back when we do cover one of our live trials in the upcoming year.
Great, thanks, Jesse. Great seeing you.